Hello, everyone. My name is David Garcia. I'm the CEO of ScoutLogic. Thank you all for spending some time with us today. Today's topic is the second in our webinar series on global screening. With me today is recognized global background screening expert, Andy Hellman. Today, we are focusing on Western Europe with a spotlight on three countries in particular, the United Kingdom, Germany, and France. Andy is going to walk through the key watchouts in each one of those markets. We may have a few minutes for questions at the end, but we may not. We will send around a copy of this recording. And if you have questions or would like to learn more about global background screening or how ScoutLogic may be able to help you, just feel free to reach out to us. You can either send me an email at david.garcia@scoutlogicScreening.com or at sales@scoutlogicScreening.com. Without further ado, Andy, feel free to take it away.
Great. Thanks very much, David. And I'm not sure if we have the slides up on the screen yet or not. As David said, we're talking about Western Europe today, background checks in Western Europe, specifically talking about compliance, looking in a little more detail at criminal record checks, because those are always a hot topic. And UK, Germany, and France will be the countries we'll most focus on or really talk about here. There's a fair amount of variation in how background screening is done, so they're also good samples, good use cases to look at, and the variability we see across Western Europe. So if we go to the next slide, what our agenda will cover today. So no talk about Europe or the UK is complete without GDPR, so we'll certainly talk about GDPR some. We will look at specific screening differences and the different types of checks across UK, Germany, and France. I'm going to dive into criminal record check restrictions a little bit more. So if we go to the next slide, why Western Europe requires a different approach? What is it about to Europe that is different than the US or other geographies? So one, first and foremost, screening in Europe is highly regulated, not necessarily as a background screening specific, but just data privacy in general is much more regulated in Europe than it is in other places. So there's very strong privacy protections. There can be strict limits on employment-related data or what data can be used in the context of employment. Criminal record access varies a lot by country. In some countries, it's more or less not available at all, and in other countries, it's used fairly widely. This last bullet here, a big one, consent is usually not a basis for processing in the EU or the UK. And the kind of little sidebar there, screening to be compliant must be necessary. What you're screening for has to be proportionate to the role that is being screened for, and it's got to be relevant. So essentially, you've got to do an impact assessment, privacy impact assessment on your background checks to make sure that those three bullets are being met, that what you're doing is necessary. There isn't an alternate way to get the information or make a determination about whatever it is you're concerned about, but it's proportionate. You're not going overboard and over screening for a role. And relevant, that you're not doing something that just doesn't really have much relevance or isn't really a reason. So, just having a kind of a one size fits all doesn't really work across Europe, because what can be viewed necessary proportionate in one country can vary to the other, mainly around criminal records, but not just with criminal records. So the one size fits all approach really is not the right way to do it and can cause some issues for you. But you'll hear GDPR referenced pretty globally these days. It's kind of become the de facto global standard for privacy regulations. And so when a new law comes up in some other country, it's almost always immediately compared to, is this GDPR like or not? Does it have this GDPR piece or that GDPR piece in it or not? So understanding GDPR is a pretty good basis to then be able to kind of interpret and digest other privacy laws globally as well. So all countries in the EU, as well as the UK, which, as many of you know, I think most of you probably know, left the EU in the Brexit. So they have their own version of GDPR now, but they all have the same guiding principles: lawfulness, fairness, transparency, purpose limitation, which means that we collect the data for purpose A. We can't use it for purpose B without going back and re-justifying why we're doing that. That we minimize the data that we're collecting. You can only collect the information that you know you need. You got to make sure things are accurate, that you have retention controls. You don't just keep data forever. You've got to have security and accountability. I mean, all these things are not unique principles to just EU and just to GDPR. And in fact, they all kind of started from the Federal Information Privacy Principles, and getting that acronym right, the FIPS, which is back from like the 70s in the US. So these are pretty standard things, but how they're implemented can vary. So again, you've got to make sure that your processing, your background screening complies with all the principles. And if you comply with the principles, then generally you can do a pretty good job complying with the regulation as well. One thing I will note, though, that is good about GDPR and about the regulation is that it's really intended to be a practical regulation in the sense that we don't see companies getting in trouble for technical violations of the GDPR, unlike what might happen in the US under FCRA. It's really about, hey, did this actually cause harm to somebody? Was somebody actually impacted or potentially impacted? So trying to maintain compliance with GDPR can go a long ways in terms of meeting regulatory compliance, making sure that the regulators aren't going to come down upon you and be upset about something. So making your best case effort can count for a lot more here than it might in the US or other locations. So if we go on to the next slide, the key thing to add on here, in addition to GDPR, which all these countries have, they all have their own individual data protection acts as well. And BDSG is just the German acronym for the German Data Protection Act. They all have their own implementing acts as well that take what's in GDPR and say, hey, here's how it actually works in our country. The UK GDPR, when UK first did the Brexit, it was just about word for word the same as the EU Act, other than switching out EU for UK. It has since varied some, so there are some material variations, but the stuff that applies to background screening for the most part is still consistent across UK and EU GDPR. The EU still granted the UK adequacy status, meaning that the EU still views the new version of GDPR in the UK as protecting data to an adequate level. So if you're concerned, you can go do some digging and some research on where things have varied. But for the most part, the parts that impact us in the background screening world are still the same. So if we can continue on. So this next one, this is a big issue. This could probably be several slides here because consent is frequently the basis for processing in a lot of places around the world. In the US, we need our consent and authorization. In the EU and in the UK, not only is consent not really the best way to do it, it can actually get you in trouble. So, say consent alone isn't enough. So, the issue with consent under GDPR is that for consent to be valid under GDPR, it's got to be freely given, meaning that the person really had an actual choice about whether they gave consent or not. Now, if you think about when someone's applying for a job, most of us are not so fortunate to either be totally independently wealthy that we don't need the job, nor that we have so many job offers to choose from that we could pick a job offer that doesn't require the background check. Essentially, people applying for the jobs need an income. They need to be able to pay for, a roof over their head and food on the table. So they have to consent, assuming they have to say yes to doing the background check. So that means it's not freely given. If it's not freely given, again, it's not a valid means for processing under GDPR. So if you take that approach, then what do we do? If we can't use consent because of those issues and challenges with it, how do we justify doing the background check? So legitimate interest, so this is Article 6.1.f, and 6.1 lists different justifications, so consent, contractual requirements, when the country laws require it. There's different reasons for doing a background check that are authorized under GDPR, but legitimate interest is the one that we're frequently seen used or the most commonly used for the basic background checks in the EU and the UK. And what this is that as a business, we have a legitimate interest in making sure the people that work for our organization are who they say they are, that they have the degree, the credential, the experience that they say they do, that they don't have some type of criminal record in their background that would present an undue risk to the organization, to its customers, to its brand, and things like that. So the business has a legitimate interest in running the background check. This is common sense, but the law enshrines it as a justification for doing a background check. Now, I'll note that legitimate interest can be used for the basic background check. but not for all the pieces of a background check. So that last bullet there, for special category data covered under Articles 9 and 10, just simply having a legitimate interest alone is not sufficient. 10 is really the important one because Article 10 is the one that relates to criminal record checks. It says that the country in which you're doing the check also has to justify or to specifically allow criminal record checks for background screening or for whatever purpose it is that you're trying to do. And then they set the process for conducting the criminal record check. And so that's the process you would have to follow. So you can use legitimate interest for doing some of the basic stuff, for conducting the education and employment verifications, for example, and that's fine. But if we're going to do a criminal record check, then we need to make sure we're complying with the specific laws in that country about how to do, when you can do a criminal record check. So the last note below this, best practice, document the legitimate business justification for every screening component. Again, this is that part when I talked about good faith effort in terms of compliance. So if you're going to run a criminal record check, say why you're running a criminal record check, not just because, but you can say, well, this role comes in contact with this class of people, or this role has exposure to cash without supervision. This role has XYZ reason that we need to do this check to make sure that some risk is being mitigated. And if you can do a good justification, if the information commissioner ever comes and wants to check and see what's going on, why are you doing this, if you've got it documented, you're probably going to be in much better condition in terms of responding to their requests than if you have really no justification and you just decided to do it because. All right, so moving on here, the other thing that's really important to talk about in addition to consent and basis for processing is international data transfers, and just data transfers in general, because this is another thing that's very different than the rules in a lot of other locations, particularly in the US. So international data transfers are when the data leaves Europe. I want to define data leaving Europe. It doesn't have anything to do with where the data is stored. This is a very common misconception. The data can all be stored in Europe, but let's say, for example, you've got a team in the US processing that data, or a team in India or the Philippines or anywhere else in the world outside of the EU or outside of the UK that's processing this data. That data is effectively transferred. I don't care if the data only resides on their screen and is never saved in that specific country. If the data is always resident in the EU, but someone's viewing this and processing it in another country, under EU regulations, that data is considered to be transferred to wherever that country is, the person is viewing the data. So it's really important to note because it's very unusual, I would say, in our industry that the data all stays in one location. We've got teams, particularly when we're running global background checks, that are spread out around the globe. You can have customer service people in one location, processing teams in another, fulfillment teams for this specific country yet somewhere else. It's unusual that data is going to stay all within the borders 100%. Almost always that data is getting transferred in some way, shape, or form. So if you're doing those transfers, you need to make sure that you do it with the appropriate safeguards and legalization of the transfers in place. So most common transfer mechanisms, either the EU-US Data Privacy Framework, or DPF, or standard contractual clauses. Those are the two most commonly used right now. And if you recall, before that, before the DPF, we had Privacy Shield, we had Safe Harbor, all kind of got struck down by the EU courts, by our favorite privacy advocate, Max Schrems. There have been talks about having additional challenges to the data privacy framework as well. For now, it's still in place. But you have to have a way to legalize the transfers. Those are the two most commonly used ones, not the only ones, but that's generally what we'll see in our space. Again, clarify, data residency is not mandatory. It doesn't matter where you store the data. What matters is where the data is transferred to. And if you transfer data outside of the EU or the UK, you've got to do it in a way that makes it legally protected. The intent of all this is to make sure that when the data is transferred offshore, that data and the data subject themselves enjoy the same protections, the same rights, the same safeguards that they enjoy within the EU or the UK. So we've kind of covered the high level information here, the general stuff. Let's dive into the specific three countries that we're talking about today, the UK, Germany, and France. So in the UK is probably the most permissive background screening environment in Europe right now. We look at criminal records. There's a couple different ways to do those. You can do your court watch list, media-based searches, which are relatively simple and straightforward. If you want to run a criminal record check where we're conducting the source at the search, you can do a basic DBS check. DBS stands for Disclosure and Barring Service. It says England and Wales here. It really depends a lot on where you are, where the job is, where the person is. But most of the time, DBS is what's done, and that's England and Wales. There are two other ways to get to the data as well. You can go through Disclosure Scotland or Access Northern Ireland. Those are used much less frequently. And I'll kind of note everything I'm talking about, the three countries are kind of typical, most common cases. As with almost everything global screening, it's rarely ever 100% black and white. Like this is the way, no exceptions, no how. The reason going through DBS or Access Northern Ireland or Disclosure Scotland is they take out what they call spent convictions from the results. And what this means is anything that's considered not to be reportable gets screened out before you ever get the results when you go through DBS, which is great from a background screening perspective because whatever is returned is reportable to an end user client. Whatever comes back in the certificate, you can report. And generally, DBS checks come back fairly fast within several days or so. It is a national level check also. It will cover any offense within the United Kingdom. Education and employment verifications are pretty standard there. It can take up to 16 days. Generally, it's a little bit faster. Depends a lot on how the data is getting sourced. There are some aggregated data sets there for education. Not every school uses it, so depending whether you're going directly to that school through an aggregated source can impact a lot the turnaround time. Financial searches are available in the UK. Here at ScoutLogic, we'll go through Experian UK to get to the data. It's more akin to a true credit check than a lot of other locations in the EU, but we can get that data. And then lastly, right to work is a bit unique or unusual in the sense that the government provides an answer on whether someone has the right to work or not. If it's a British citizen, we can do a digital identity verification to confirm they actually are a citizen. If it's a non-citizen, there is a government right to work process where you can go and confirm with the government whether this non-citizen does indeed have the right to work in the UK or not, and whether there's any restrictions on that, which is nice to be able to do that more definitively. Part of the reason this exists is because right to work in the UK is a very regulated process that quite actually carries civil penalties for the HR people that are conducting the right to work check. So you need to make sure that if you are hiring in the UK, that you make sure you are complying with the right to work requirements because there can be big penalties for that. So we hop across the channel, we go over to Germany. Germany is much more restrictive with respect to criminal records. So employers can't directly obtain criminal record checks. You can ask a candidate to provide, but what that is the certificate of good conduct, clearance certificate. There's different names for it, but it's a criminal record certificate that the authorities issue. They will issue it to the candidate, but not to the employer or to the background screening company. But it's really only justified for very specific roles. So you need to be careful making sure that if you're asking for that, that it is a role that this can be justified in requesting the certificate. Education employment verifications generally available without a problem. Financial checks, again, yeah, we can do those through Experian. It has a fair amount of depth to the data there, which is great. We look at right to work checks. Here, we're going to have to do a verification of the documents being provided. It's not done directly with the German authorities. It's just done saying this looks like it is a valid work visa or an ID document or a work permit or whatever document we're looking at. So not quite as strong as what's in the UK, but we can go look at those documents and confirm they seem to be authentic and belong to the person in question. Germany is definitely a bit stricter on what can be done and is a little more employer friendly or leans more towards the employer side and kind of the balancing of what's proportionate and justified. All right, let's move on to France here because I know that we just got a few minutes left to try to get this wrapped up and allow some time for questions. So, France, again, criminal records very restricted. Only for some very specific roles can they be done. And again, in these cases, you ask the candidate to get their certificate and show it to you. Education and employment, just like the other two countries, can be done without too much of an issue. Financial searches can be done there. They're not quite a full-on credit check like in some countries. And then right to work, similar to Germany, we can do validation of ID documents and so on to try to make sure that it looks like the person has the right to work, but it's not an actual verification directly with the government source. So past France, we look at, high level, what are the critical compliance risks to look at? France, criminal record checks. If you don't do this properly, you do it and you're not supposed to, can be big trouble, large fines and imprisonment. So make sure that you are following the rules and the regulations in France. Germany, interestingly, directorship limitations. So we can't just go check past directorships and see what someone's history was. So this is one of those things where you want to work with, your scout, make sure if you're trying to figure out what you can and can't do, to figure out what's available, what can be offered, and are there any restrictions or caveats, like can't do this if the person's in Germany, but if they're out, you can, or vice versa, things like that. Ultimately, just taking a US program and lift and shift over to Europe is not the best way to do it. You need to say, okay, here's what I'm doing in the US or wherever else. I'd like to get as close to this as possible. How close can I get without running afoul of the rules and regulations? It's probably the best approach. So moving on, there's some operational challenges that can come in with this. You want to make sure that we try to avoid these because it can delay things. So making sure that we have all the information, all the names, date of birth, IDs, address history, things like that. You can get the ordering requirements in advance to help out and provide those to the final customer and to the candidates to get them prepared, letting the candidate know that it may involve some participation on their part, doing digital ID, biometric scans. Some fulfillment methods may have somebody needing to log into portals and things like that. And sometimes we're just dependent upon the government agencies that we can't really do much to impact those, and that can delay things. So moving on, how do we deal with that? What are the best practices to improve turnaround times? Again, make sure that the person knows the information they're going to need to pull together so they can start working on that. Help them collect or let them know they need to collect things like diplomas or pay slips or reference letters. Arbeitszeugnis in Germany, that is a very specific work reference letter that an employee gets when they leave a company. So they have those things kind of compiled. Sometimes they may not always have it handy. Make sure that candidates on the lookout for requests, whether it's because of missing information or to do an ID check, things like that, that they respond quickly. They're checking the junk mail folders, all those kind of things. Lastly, if you can pre-approve out-of-pocket charges, third-party charges, government fees, and things like that, that can also delay turnaround time. That can help speed things up. So if you can get all those things done, it usually means that things will go faster, smoother, and be a better overall candidate experience. As we all know, candidate experience matters. Screening, unfortunately, or fortunately, depending how you look at it, it's becoming more interactive than it used to be. So we need to have candidates prep for this and be ready. It's no longer a question of filling out an application, submitting it, and waiting for the background check to get finished a week or two hence. So make sure they're ready and prepared for everything. So the last two slides we've got here, as I kind of talked about already, make sure that you're making sure things are relevant, that you're doing your privacy assessments and all those kind of things. Don't just lift and shift a policy over to Europe and put it in place. And then the final slide, make sure that you're actually looking at the details and the documentation, that you're talking to your scout and your team about the compliance requirements, make sure you get things right, that you get aligned to GDPR and country-specific requirements, which is very important. With that, I'm going to wrap up very quickly here. David, I'm turning it over to you. If you have any questions from the audience, anything else to throw in here before we finish up, hopefully in 3 minutes hence.
I think you're the only person on the planet who could do Western European background screening themes in 27 minutes or less. So Andy, thank you so much. Actually, we don't have any questions, so I think we're good to go to wrap this up. For those of you who joined, thank you so much. Again, we will share a copy of this. If you have questions, feel free to email us at any time. And again, Andy, thank you for a lot of rich information in a very short amount of time.
My pleasure.
All right. Thank you, everybody. Have a great day.